Welcome everyone. I'm going to give you a minute to log in from the waiting room while I get the closed captions up and running. And when those are up and running, you should see a red live box on your screen. So you can click on that to follow along with the closed captions. All right, that should be up and running. So welcome everyone. I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services. I'm really excited about this panel today, and we've had such a great response. So thank you all for registering for this. It is being recorded, and the recording and the materials will be sent out tomorrow. It's also been approved for CLE credit, including ethics credit. So that information will be posted at the end of the webinar and will also be in the follow-up email. So today I have to thank the Public Interest Law Section Nonprofit Legal Work Group. They are the brainchild behind this wonderful topic today, especially the chair of that work group, who is Jeff Fromnick. You'll see him on your screen. He's counsel at Dentons, Cohen, and Grisby, and also an attorney at Lawyers for Nonprofits. So thank you, Jeff, for coming up with this topic and putting together a wonderful panel. I do want to let everyone know that if you're joining from Pennsylvania or any other state besides Florida, if you need help claiming the CLE credit, just reach out to me. And I'll also post the information in the chat for Pennsylvania attendees particularly. You will need to email info@nonprofitissues.com, and they will help you with the CLE code. So I'll put that all in the chat, and without further ado, I will pass this over to Jeff.
All right, thanks, Christy. And I want to thank everyone on the Public Interest Law Section Nonprofit Legal Work Group, Daniela, who's one of our panelists today as well. They helped come up with this topic, and we've been planning this CLE for a number of months. So we're happy that it's here and that we have so many people interested in it. I want to give a shout out and a plug for the Public Interest Law Section of the Florida Bar. It's our mission to provide an organization that's open to all who have a common interest in advocacy and enhancement of constitutional, statutory, and other rights. We're a small but mighty section. Our dues is only $35 a year. And so I encourage everyone that's on the webinar today, if you're not already a member, to join our section. The Public Interest Law Section is really a unique collection of different attorneys. And so we have a number of different substantive work groups that I have up on the screen right now. We call them our subject matter work groups, and we ask all members to join one of them. So today's is brought to you by the Nonprofit Law Work Group, but we also have work groups around children's rights, civil rights, consumer and tenant protection, disability, homelessness, immigration, and parents advocacy. So each of these work groups meets on a regular basis, produces training materials, and has in-depth discussions around their practice area. So if you practice in any of those areas or you're interested in any of those areas, we encourage you to, again, join our section and sign up for a work group. I want to thank our sponsors today. First and foremost is Don Kramer's Nonprofit Legal Issues. Don's one of our panelists. And he also, Nonprofit Legal Issues is a monthly newsletter and webinar series on the nonprofit legal issues that you need to know. He also produces a number of handouts, and it's a great resource if you practice in this area or if you serve on a board and just want to get more information about some nonprofit legal issues. I also want to thank Lawyers for Nonprofits, which provides pro and low bono legal help to small and startup nonprofits in Pennsylvania and Florida. As well as the Florida Legal Services Statewide Training Initiative, and Christy Baglow, who is the brains behind all of the technology and the signups and the Zoom. So we thank Christy for managing this, not only for this our work group's presentation today, but all of the Public Interest Law Section's webinars throughout the year. So very thankful for Christy's work on that. And I'm going to quickly introduce our speakers today, and then we're going to get into our hypotheticals. So we have a series of hypotheticals. It's going to remind you of a law school exam. Dawn's going to lead us through that. Dawn's our moderator today. Dawn is the chair of the Nonprofit Law Group at the Philadelphia law firm of Montgomery, McCracken, Walker, and Rhodes. Dawn has more than 40 years of experience dealing with the concerns of nonprofit organizations, not only as a lawyer, but also as a teacher, writer, publisher, and board member. As I mentioned, he's the editor and publisher of Don Kramer's Nonprofit Issues, a national electronic newsletter and website of nonprofit law you need to know. He frequently lectures on nonprofit legal issues and has taught courses on nonprofit organization at the University of Pennsylvania Law School and the School of Public Policy and Practice at the University of Pennsylvania and Eastern University. Mr. Kramer serves on the board of the Philadelphia Fire Department Historical Corporation and served on the board of the Pennsylvania Association of Nonprofit Organizations for more than 30 years. He's a graduate of Princeton University and earned his law degree from Harvard Law School. So thank you, Dawn, for being here today and being our moderator. We have an amazing panelist of Florida lawyers. I'm going to go in alphabetical order here. First up is Phil DeComo. Phil serves as outside counsel to businesses, entrepreneurs, and nonprofit institutions. He concentrates his practice in the area of emerging companies and general corporate law, including nonprofit organizations. Mr. DeComo represents an exempt organizations ranging from providing guidance on board governance matters, as well as business and donor agreements. He reviews commercial co-venture arrangements, joint ventures, and strategic partnerships, and helps with nonprofit mergers and other complex transactions. Prior to his law practice, Mr. DeComo had more than 15 years of communication, fund development, and executive management experience, primarily in the nonprofit sector. He's a member of the Florida Bar and serves as a director at Nonprofits First and as a director at the Palm Beach County Cultural Council. He's on the American Bar Association's Nonprofit Law Committee, and he has earned his chartered advisor in philanthropy from the Richard Irwin Graduate School of the American College. He is a recipient of the 2004 Nonprofit Law Award from the Legal Aid Society of Palm Beach County and is a member of Leadership Palm Beach County class of 2012. So thank you, Dawn. Next up is Daniela Simo. She's a staff attorney at the Legal Services of Greater Miami, where she provides transactional legal services, legal education, and technical support to community-based nonprofits and other small and startup businesses. She earned her JD from the University of Miami and her bachelor's from George Washington University School of Media and Public Affairs. She's a member of the Florida and DC Bar and serves as the Young Lawyer Committee Pro Bono Chair for the ABA Business Law section. Thanks for being here today, Daniela. We also have a poll that everyone's responding to, so we thank you, and we'll touch on that once everyone's had a chance to respond. Our next panelist is Jennifer Gomez. She's an attorney licensed in Florida and New York, as well as a partner at the WFB Law firm. She assists clients on all matters related to estate planning, including wills and trusts, charitable planning, retirement planning, asset protection, tax planning, estate administration, and business planning. She has devoted her life to helping people protect what matters most to them and believes in giving individuals and families peace of mind through preventative planning. She's a Florida native residing in Palm Beach County and gives back to the community, serving on a variety of nonprofit boards such as Community Greening, Mission United, St. Joseph's Episcopal Church, and Tomorrow's Rainbow. Ms. Gomez frequently lectures on important legal topics for educational and civic organizations. She is also a foster caregiver with the Coastal Poodle Rescue and mom of Roger, a rescue bergdoodle. Thank you for being here, Jennifer. And last but not least, our last panelist is Kathleen McElroy. Kathleen is a shareholder at Carlton Fields, where she represents creditors and real property owners in disputes with commercial parties in all forms, including state, federal, and bankruptcy court. She attained her certification from the Supreme Court of Florida as a circuit civil and county court mediator. She's also certified to serve as a mediator in matters pending before the U.S. District Court, Middle District of Florida, and the United States Bankruptcy Court for the Middle District of Florida. She is active member and fellow of the American Bar Association, having served in various roles in the ABA Business Law section, including as a member of the section's council, chair of the ABA Business Law section's Pro Bono Committee, co-chair of the section's Leadership Development Committee, and member of the Business Law Today editorial board, and a longstanding member of the National Public Service Award Selection Committee. She presently serves as vice chair of the ABA Business Law section's Business and Corporate Litigation Committee, and she has served as the ABA Standing Committee on Pro Bono and Public Service and the ABA's Commission on Interests of Lawyer Trust Accounts. She's an active member of the Florida Bar, presently serving as the co-chair of its Standing Committee on Pro Bono Legal Services and co-chair of the Florida Bar's Alternative Dispute Resolution section. She has served as vice chair of the Florida Bar's Continuing Legal Education Committee, served on the Florida Bar Standing Committee on Professionalism, and as chair of its Grievance Committee. She is the past president, former member of the board of directors, former endowment trustee, and fellow of the Florida Bar Foundation. She is currently the chair of the board of directors of the Florida Justice Technology Center, Inc., a statewide nonprofit created in 2015 with grants from the Florida Bar Foundation to increase access to justice through the innovative use of technology. She was appointed by the Supreme Court of Florida to the inaugural Florida Commission on Access to Justice and served on the commission's executive committee and chairs its resource evaluation committee. So thank you for being here, Kathleen. Okay, so before we get into the hypothetical, we're just going to reference this poll. So we did a poll of whether you currently serve on a nonprofit board of directors. 59% of you said yes, 36 said no, and 4% say you've been invited and haven't decided yet. So hopefully this panel discussion gives you some things to think about while you're making that decision. And for the 36% that said no, we hope this doesn't scare you away. We hope it gives you some things to think about and encourages you to join. As you heard everyone's bio, everyone's involved on some boards of directors, and lawyers are oftentimes asked to participate. So without further ado, we're going to get into the first hypothetical. I'm going to read it, and then Dawn is going to lead a discussion around it. I'm going to read it for the folks that are maybe not on video. Our theme is, what should Larry do? So Larry is an associate in the trust and estate group at a firm in Orlando, Florida. During his annual review with one of the managing partners, Larry mentioned that he'd like to get more involved with the local community and help build his practice. The partner suggested that Larry join the board of a local nonprofit and provided a list of 501c3 public charities in the area. Larry immediately recognized one of the organizations, Superstar Youth, Inc., because his good friend Michelle is the executive director. After his meeting with the partner, Larry called Michelle and told her that he was interested in joining the board. Michelle told Larry that he would be a great fit because there were no other attorneys on the board and they were eager to add one. She promised to recommend him to the nominating committee and help him fill out a board application.
Okay, we started out with Larry the lawyer here to be the person who will embody all the problems that we raise. Hopefully not so many problems that you will be scared away, but hopefully giving you some ability to deal with the issues that do come up when you have this dual role as lawyer and member of the board. Let me start by asking, does it make sense for Larry to go on the board of Superstar Youth if Larry is a trust and estates lawyer and wants to build a practice? Jennifer, you're in this field, so I'm going to pick on you at the outset. Does it make sense for Larry to go on the Superstar Youth people? It doesn't sound to me like there are many will candidates or estate planning candidates that he's going to run into.
Yeah, it's very popular for attorneys to want to join a nonprofit board to get out in the community and network, but depending on the particulars of what this organization's doing, it may not be the best fit for that. They might look into other networking groups, nonprofit councils, and things like that, where there's more of high net worth clientele and things like that that might be better for the networking aspect. But if it's an organization that he is passionate about their mission, then there's certainly other things that outweigh that networking component.
Yeah, it seems to me that if you were to join the Association of Fundraising Professionals or the Planned Giving Council, most of the people there would be potential clients. I'm not sure who Superstar Youth will be pending clients. But let me raise the question, is it ethical even to consider this? Is this an appropriate consideration?
I think it is.
Yeah, I think it is too. I think the commentary to the Code of Professional Responsibility allows you to consider that. But what should Larry consider about taking this position, about going into this? What is the first requirement of a lawyer who takes on some sort of an engagement? Daniela, you were nodding your head. Do you have a comment on that?
Yeah, I think Larry should consider what his role is going to be in the organization. And so if he's joining as a board of director, as a director, he's going to become a member of the board. But the fact that sticks out to me is that, Michelle told him that he'd be a great fit because there's no attorneys on the board. And that makes me think that they want Larry to provide legal advice on the board. So Larry may want to find out from the board and from Michelle, well, why do you want me to join because I'm a lawyer, and do you want me to provide legal advice? I think that's, and if the answer is yes, then maybe he wants to, provide legal advice to the organization and retain them rather than join the board.
But they don't have any money. That's why they want them to come for free.
Well, he could provide pro bono. He could retain them on a pro bono basis.
Okay.
Don, I think that he needs to run conflicts.
Yeah. Well, let's talk about what due diligence should Larry be doing. I think Daniela raised the question of the expectations, and I think that's really one of the fundamental things. What do they expect of Larry when he joins? But what else would you do in the way of due diligence to see whether this group is really the group that you want to go and participate with, just because, Michelle, the CEO, is the friend of yours?
Don, I think that's the really important point, the fact that Michelle is a friend, because what Larry may or may not know is that one of his directives as a member of the board is that he's responsible for oversight, including doing the reviews of the executive director and potentially hiring and firing that person. So I think that's one key issue and consideration that he needs to be aware of. But just from a diligence standpoint, I think if you're going to join a board, I think Daniela said it, you should, or maybe it was Jennifer, you need to be passionate about the mission and the purpose of the organization. You need to have an interest and be willing to commit time to it. And you should understand the organization. And the best way to do that is to ask the other board members and ask the executive director, but then also to dig into the 990s, which are available online, to look into the organization. And it's very simple to do now through the Secretary of State's office, through the IRS and GuideStar and other areas.
What about reviewing board minutes and doing those kinds of things, pursuing, more specific information from the organization?
I think that's perfectly fine to do that and to ask to review that, and it gives you a sense of how the board operates, which is probably really important.
And what about clearing it with your own firm? Is that relevant or important? Kathleen?
I think so, because even if you're going to serve in a business capacity, I think it has the potential to raise some conflicts, or at least some difficult situations. For instance, if you have a client that does business with the entity, or a client who's contemplating suing the entity, things like that. So I think that that's important. And then I think, at least with respect to how my firm's malpractice coverage works, there's coverage for board service so long as it's been disclosed in advance. So we have a process where I have to announce that I'm interested in serving on the board. The firm does some due diligence, like the 990 review, looking at the bylaws, asking about whether the organization has officer and director coverage and things like that, and then makes a decision about whether or not it's a good fit for the firm and the lawyer, and then discloses it as part of the malpractice coverage. Part of that includes a conflict search to make sure that there's not any obvious issues. And part of our internal due diligence also often includes a litigation search to see if there's pending lawsuits against the potential client or party that you're inquiring about. They would look at all those things and help the lawyer make a determination about whether it makes sense to serve in the capacity of a board member for the organization.
Yeah, I think those things are all important. They don't, even if they come up adversely, that doesn't mean you can't serve under the right circumstances with that in mind and understanding what you're getting into. But I know our firm will not let us participate unless the organization itself has an array of insurances which will protect us from our board service. Okay, let's go on to part two, because we'll find out how some of these things work as we get there. Jeffrey? Part two. Yeah, there we go. You're going to read
Sorry,
that?
Don. Yeah, I will. I was struggling a little bit with my technology, but part two. Larry, for those not on the video, Larry received an email from the president of Superstar Youth informing him that he was added as a board member in accordance with the organization's bylaws. He was invited to serve a 3-year term and was required to attend a board orientation, along with 2 other new directors prior to attending his first board meeting. Prior to accepting his new role as a director, Larry submitted a letter addressed to the board, which clarified that his role would be that of a director, and that he would not serve as general counsel or provide legal advice in connection with his board service. At the first board meeting, Michelle, his friend, asked to add an item to the agenda, which requires immediate review by the board. Michelle has been asked to attend a fundraiser for the mayor's re-election campaign that evening, and has asked the board to approve a $1,000 donation to the mayor's campaign so she can attend. The board members are not sure if this is legal and asked Larry for his opinion. Larry doesn't know a lot about nonprofit law, but he does know that Superstar Youth could lose its charitable tax exemption if it makes such a contribution. He also knows, as he said in his letter to the board, he doesn't want to provide legal advice to the board.
All right, so what does Larry do now? Kathleen, you're of the view in general, I take it, that you don't really want to be the lawyer on the board. And I think you've said you've submitted these kinds of letters in the past. Why do you have that view? Why do you want to do that?
Well, the role of the lawyer for a board or an organization and a member of a board are very different. The board member is to provide business input and to make decisions. Lawyers are to provide guidance, particularly legal guidance as to issues. And the roles should be separated whenever possible because of inherent conflicts and problems that can arise when you're seen as both. And unfortunately, being a lawyer on a board sometimes is like being a lawyer on a jury. Everyone looks to you for anything that has to do with the law because they think you know more than they do. And that sometimes is hard to overcome.
Sometimes you do know more than they do, right?
You do sometimes. I typically send a letter. I also typically, probably more than people want to hear, will say to them when an issue comes up, for instance, if it's not an area of law that I know much about or not my area of specialization, I'll say that. I'll say, I'm here as a board member, not a lawyer. I don't practice in the area of XYZ. As a board member, I'm going to make this decision. I'm going to vote against this, for instance, because I think it creates a problem. I'm not here to give legal advice, but that's my personal opinion. And because of that, as a board member, I'm going to vote against, in this case, for instance, making this contribution because I think it presents problems and we should get counsel. And it's unfortunate that we don't have a lot of time to do that, but I personally believe that it may create a problem and I will be voting against it, not as a lawyer, but as a member of the board. That would be my inclination of what I would do. And that's typically what I do. I've been in organizations where various issues, tax issues have come up. I'm not a tax lawyer. And I'll say that. And I'll often volunteer to get them a lawyer or help them find prospects of a lawyer. I'll help you find a tax lawyer to help you with this tax issue because I don't know.
Well, I fully understand that when you're coming into an area in which you don't have the experience and you would ordinarily with any client, you would go and tell them that, I'll get somebody else in the firm to answer that question or do something like that. But here, I think you're in a little different position because even though you say you're not the lawyer and not providing legal services, and even though you say that periodically, is that enough to keep the people who, agreed to your election because they want the lawyer on the board? And who determines whether you have an attorney-client relationship? Do you or does the putative client?
I think I think in Florida, it's what the client believes, which is why I often say I'm not. And I usually try to give the business reason. As a business person, I'm going to do it because of X. Like for instance, I think in this particular hypothetical, it might be fair to say, if we don't have time to get the answer, then we probably shouldn't do it because we perceive some risk and we don't have time to get the answer. I mean, I don't know if that's the right way to handle it, but I think it could be because you could say, if you don't know for sure. Now, our hypothetical, I think, says Larry knows that. And maybe he has to say it if Larry knows it. But, if Larry says, I am fairly certain that's what the law is. And someone says, are you positive? And he says, I don't know. I think Larry could back that up with, if we perceive this as a problem, then doing nothing is better than doing something that creates the problem because this
but I think you're dodging the issue there because Larry can't say, I think this might be a problem, because Larry knows it is a problem.
Right.
And can Larry say anything else? If Larry stays silent, has he breached his duty as a director and allowed the organization to get into bad trouble?
I think he has to say something. I think his fiduciary duty requires him to say something. And it's unfortunate because it does bleed into legal advice, but I think he has to say, nonprofits like us run the risk of getting into trouble with our tax exemption if we do this. And then I would say, and this may be wrong, and Don, you're the expert in this area, I think I would say then, and for that reason, as a board member, I am going to vote against this.
Yeah, well, I certainly would say that. I mean, but I think, I find that lawyers can't remain silent. And so when a question is given to them by the other people on the board, they're going to do their best to try to answer it. And that they just can't dodge it and say, well, I think you ought to do this or that other kind of thing. I think that, you know, if Larry didn't say in this case that if you do this, you risk your tax exempt status, he would be breaching his fiduciary duty as a member of the board. Does anybody disagree with me on that?
I think it also brings up the question as, you know, of the fiduciary duty, you have the duty of loyalty, duty of care, and we know that there's case law in the securities law context that said a lawyer has a heightened duty. And, you know, whether that applies to the nonprofit context or not, it's arguable, but I think, you know, I could argue that it does apply here. So, and I think that's one of the issues is that conflict between, you know, wearing your hat as a board member and your fiduciary obligations versus your obligations as an attorney. And to your point, Don, you know, as Kathleen said, the who determines the relationship is the prospective client. You know, it's their take on what it is. And so I think you always have that conflict where the other board members are looking to you as the lawyer. And I think you do have to say, I'm not acting as a lawyer, you know, we need to contact our general counsel. And the other thing I'll add here is the competency issue is huge. I mean, that's 1.1 of the model rules, right? The very first, the model rule is you need to provide competent reputation. You need to be competent in your representation. And the thing that I see as outside counsel is either an organization coming to me and doing something, and when I tell them the issues with that, they say, but the lawyer on our board said it was okay. It's like, well, then the lawyer on your board wasn't competent to tell you that. And the other thing that I see is lawyers coming to me who are on board saying, I know what I don't know, so we need your help because we need someone who's an expert dealing in these nonprofit issues. So it's difficult being that nonprofit lawyer on a board.
Yeah, I think this is an issue inherent in being a lawyer on any board, nonprofit or for-profit. But I think it makes it hard to disclaim. We did this in Pennsylvania Bar Institute program many years ago. And after debating for 10 or 15 minutes whether you were the lawyer for the board or not, some consultant in the audience, stood up and said, if you don't think you're the lawyer for the board, you're not understanding why you're there, because that's exactly why they asked you to join. But let me change the hypo a minute. Larry likes the mayor and says, absolutely, let's go and make the contribution. The IRS comes by and they get an investigation, and ultimately they lose their exemption. Some of the other people on the board who thought Larry was the lawyer sue Larry for malpractice. Has Larry disclaimed his insurance by saying he's not the lawyer and is not going to give legal advice? I don't know the answer to that question, but I would seem to me, I've never met many insurance companies which expand the scope of their coverage and would happily say, well, despite the fact that Larry said he wasn't a lawyer and wasn't giving legal advice, we're going to cover him anyway. I think that's a real risk. I think that's
and I think also Kathleen pointed out that their carrier at her firm, you have to provide notice of serving on a board. there are a lot of professional liability carriers out there who don't consider service on a board as part of your pro bono service or as part of what's covered by their policies.
Yeah, and I think the D&O policies primarily exclude somebody's providing their own professional
right.
services. So you would be without coverage either internally that we all want to have for ourselves, and perhaps from the law firm issue for the legal malpractice as well.
Yep. And there is vicarious liability potentially if it's a fiduciary duty breach by the director who is an attorney.
Mm-hmm. Mm-hmm. And the standard of care, just under the basic state nonprofit law, is as a person of reasonable intelligence in similar circumstances would apply. And if you have a heightened duty because you're a lawyer, maybe you breach that if you don't apply it correctly. Okay, let's go on, Jeff, to number 3.
All right, number 3. At his second board meeting ever, Larry learns that the organization is in financial trouble. The chief financial officer reports that the organization is a month behind on rent, and it does not have the funds to pay rent for the next 6 months. A demand letter for payment from the landlord's attorney is shared with the board, and Larry immediately notices that the letter was sent by a partner at his firm. The directors ask Larry what they should do.
And what can Larry do in this circumstance? Can Larry offer to talk to his partner and try to resolve the issue? Does Larry have a conflict of issue here? Conflict of interest issue here? Is there a conflict?
I think in this case, there is. It's a concurrent conflict.
And what does Larry do? What creates the conflict? I mean,
I think because the knowledge of the law firm is imputed to Larry, and he also is on the client side as a member of the board of the organization, I think
Yeah.
that creates a conflict.
and there is an opinion that Jennifer found from Ohio, which is an interesting one, which she sent to us, saying that because Larry is a lawyer and is on the board, there's a non-waivable conflict. So that doesn't depend on whether Larry is saying he's giving legal advice or not. That is an inherent and non-waivable conflict because Larry is a lawyer and not an interior designer. And that's what created the conflict that Larry has to deal with now. So what can he do? What should he do? Daniela?
Yeah, I think Larry needs to first and foremost recuse himself from this matter, potentially step down from the board. I don't know if anyone else agrees, but he definitely can't be involved in any discussions regarding this matter because of the conflict on his firm side. So I think that's the first step, and whether he can actually, I think he has to advise them to get counsel for this matter.
Yeah, I mean, I think that's the only thing that the lawyer can do in this circumstance, right? Is to say, get a lawyer. Because anything beyond that, I think would be violating the legal ethics because there's this non-waivable conflict there.
Doesn't he also need to let his firm know that he's on that board, because apparently they
Yes.
missed it somewhere along the way?
Yes, and this, goes back to what we were talking about, due diligence, determining to go onto the board. That if you had opened a file in the name of the organization where you're serving on the board, this conflict would have been found in any conflict search. And this would not be likely to happen. But again, it's one of the things, the prophylactic things you got to do early on to make it work. Okay.
Don, we have a couple of questions. We appreciate both of them. One of them is basically an additional hypothetical. We're going to let that one simmer. We have enough hypotheticals to go through. But the other one, I think, raises an interesting question. And she asks, or the anonymous attendee asks, when is someone officially on a board? And when do the fiduciary and other legal obligations apply? Does it have to occur? Do you have to have a written agreement? I don't know if Phil or Dawn, you want to answer that. I mean, I have an opinion on that, but curious to see what you guys think.
My reaction would be when you're selected and you accept, you're on the board.
Yeah, which is different than one of you, their lawyer, because when a potential client calls me on the phone and says, I think I might want to hire you, let's discuss it. At that point, your obligations kick in, right? So I think that's the dichotomy. When are you officially on the board? Well, when you've gone through the process and been officially elected pursuant to whatever the bylaws say on the board, you are now officially on the board and you have those responsibilities, which is a little different than when you potentially have an obligation as a lawyer.
Yeah, and I think it highlights too the idea that when you join a board, it's not just a resume builder. That even in the hypothetical here, where it's a small board, you've only met one or twice. If you've been elected to that board, fiduciary responsibilities attach, whether you want them to or not. So great question, and we're going to move on to the next hypothetical.
Yep, let's go to number 4.
All right, the president of the board sends an emergency email to the entire board and calls a special meeting. The purpose of the meeting is to discuss an allegation that Michelle sexually harassed one of the employees. After receiving the notice, Larry gets a call from Michelle, who wants to get his advice on this issue. Larry previously represented Michelle in a criminal matter involving an aggravated assault charge.
What should Larry do? Phil foresaw this coming, right, Phil?
That's right. I think Larry is wearing his board of directors hat, and I think, you know, he cannot represent Michelle. He cannot talk directly to Michelle. I think, you know, the board needs to take specific action. And I think this is incredibly serious. And one of the issues why you have to be very cautious about serving on a board where you're friends with the executive director.
Now, is Michelle a former client here? Does he have to worry about all the issues that a lawyer has about confidentiality and other issues of a former client?
I think in this case, I think the first thing is that it's a very different type of representation. It looks like it was a criminal matter that's been resolved and ended. You know, having said that, I think he has to tread pretty carefully.
Yeah, I mean, I think he has a former client here, and he may not have learned anything confidentially in that earlier representation, which would be relevant here. But her proclivity for aggravated assault against her friends may well be relevant here. And when he comes to serve on the board and they're determining whether or not they're going to sanction Michelle or do something because she's harassed an employee, is his knowledge of her prior criminal activity or alleged criminal activity relevant to that? And can he talk about it? And does he have to recuse himself from all discussion because he knows that Michelle really isn't a very nice person, despite his friendship? Is he precluded for that?
I think so. I think he has to recuse himself from this discussion and anything related to sanctions against Michelle. Yeah, I think he would. It's a really, we created this hypo because it is a difficult situation. It's something that could happen, but I think he has to step down and not take any action on those matters or have any discussion in those matters.
Would it be different if it were Jennifer's estate planning client and he had represented her in drafting a will, but knew nothing untoward about her at all? Would that make a different situation?
I think with different practice areas, then it's different facts or information. So it is a bit of a different situation if it's another criminal matter versus a completed real estate transaction or a completed estate plan.
Can Larry tell the board that Michelle had called him at this point?
this is a really sticky issue because again, which hat is he wearing? And I think he has an obligation, a fiduciary obligation to the board. And you know, I would lean towards that in this case and say that, you know, he maybe should do that, but recuse himself from any further discussion and be very clear that he's not had any discussions on this topic.
Well, that's an interesting question. I mean, it seems to me that if he decides he has to recuse himself in part because he knows that she's got a mean personality or whatever, then he also would not be in a position to tell a former client, to tell a current client or a current board what his former client had done. If it was the completed will, maybe it's a different situation. But I think it does raise interesting questions there of what you do. One of the questions we had when we were discussing this is, should Larry have told the board originally that Michelle was a former client? And there again, if he had represented her in a aggravated assault charge, which was a public trial, that's all public information. But should you go around telling people public information, which is adverse to them, just because it was public? Did he have any?
And what does the organization's conflict of interest policy say? How broadly does it define a conflict? And would that be picked up by that policy, with that relationship? You know, again, creating a very difficult situation for Larry.
That's an interesting question. I don't think that our standard conflict of interest policy would pick that up because it's not a current economic activity, which is what mostly I think these conflict policies deal with. But they don't deal normally with other kinds of representations like that in the past.
Dawn, if I can, we had a question come through the chat. I think you guys may have addressed it a little bit, but with Larry's prior representation of Michelle, should he even have accepted a position on this board?
Anybody want to respond to that? I'm only the question asker. I don't answer. What do we think?
I think he could accept it if he disclosed it. I think that would have been the better case was to disclose it and have that conversation with the board prior to joining the board. And so this way there's an awareness of it in case something does exist, and people can react appropriately if something like this hypo comes about with that knowledge.
Okay, then we have one last question on, does the heightened duty for lawyers apply to the same extent in situations in which most or all of the members of the board are lawyers, such as a board of a legal services organization?
Anybody want to respond to that?
I would say yes, you know, although again, you know, it could be arguable whether that exists or not at all, because the case law isn't entirely applicable, but I would argue that it likely is, and that it would apply to all of the lawyers.
Yeah, I think it applies in general terms. I think it's less likely that they're going to look to you for specific legal advice. But the whole issue we had when, you know, Larry's partner was threatening to sue, that just arises because Larry is a lawyer and is on the board, without regard to whether he's giving any legal advice or being looked to for legal advice. And that's just a consequence of your being a lawyer in a law firm, which arises in all sorts of situations that we have to deal with. Okay, let's move on to number 5, Jeff.
All right, part 5, we're almost done with our exam here. In his private practice, Larry talks with I.M. Loaded, a longtime client of the firm who is charitably inclined and interested in a charitable remainder trust to provide her with lifetime income. She doesn't particularly care which charity gets the remainder. She just wants the steady income. As a member of the Superstar Youth Development Committee, Larry knows that Superstar Youth would love to receive a charitable remainder to support its programs. What should Larry do?
Jennifer, you're the estate's lawyer. This is especially for you.
Thank you. So I think it does present a conflict of interest, and different states have come to different conclusions as to whether or not it's a waivable conflict of interest. I think you said Pennsylvania, it's a waivable conflict of interest. Is that correct?
Yes. It's
And-
waivable in Pennsylvania, waivable, of course, by both sides,
Mhm.
both the charity and the individual.
Mhm.
Yes.
Yeah, and based on the Florida ethics rules 4-1.7 for conflict of interest, I think that out of abundance of caution, I would not take on representation in that kind of a scenario. Maybe someone would come to a different conclusion, but it's also important to note that the conflict would be imputed to other members of your firm, so you can't use that as a way to work around it as well.
What is the risk? What is the conflict that you're worried about? Presumably, I Am Loaded wants to have a charitable remainder trust, get money, life income, and presumably would like to get the remainder. So everybody should be happy, right?
So the client creating the trust later wants to recoup the principal of that trust, there could be a conflict there. I think it's a different scenario if it was just a charitable request in a revocable trust. I don't think that presents the same conflict of interest there.
Yeah, I think part of the conflict here is because with the charitable remainder trust, the remainder can vest or not. It can be left to the trustee later to decide which charity to give the money to. So if you're on the side of the charity here, you want it vested in you. And you don't want to give that latitude. But what if your charity is willing to let you do that? The charity knows that you're going to say it doesn't have to be vested if she doesn't want it to be vested. Does that make a difference?
So if you're in a state where you can waive that conflict and both the client, I Am Loaded, and the charity both waive that, then I think you could proceed.
Yeah, the risks I think are real. We didn't hypothesize I Am Loaded's family situation, but it often comes up with a person who doesn't have immediate family and who's got nieces and nephews who ultimately argue undue influence. And that, I think, is where this comes up primarily. And even if it's a waivable conflict, it may not be one that you want to waive because there's a lot of litigation which comes out of those cases. And if you're in the middle of it, if nothing else, you have to defend yourself, which is not the way you want to spend your time. Okay, let's go to number 6, Jeff, because now we get into some really interesting stuff.
All right. Larry learns that Michelle has been stealing from the organization. 2 years ago, she set up a separate company that she has used with phony names to bill Superstar Youth for services that were never provided. Over the period, she has improperly misappropriated a substantial sum, an amount that would have to be reported on the 990 tax information return.
So what should Larry do now? Who has a suggestion?
Well, as a board member, I think Larry needs to tell the board, possibly call a special meeting and disclose this information that he's learned, because it would be in the best interest of the organization to know that this executive director has been stealing from the organization.
Is that where you would start? Would you start with a full board meeting, or would you start with the president of the board?
Yeah, you'd probably start with the officers of the board or the maybe the executive committee. But yeah, you could email or contact the president of the board. I would start with the executive board.
Okay, and what would you recommend at this point? Would you recommend calling the police?
I can tell you what I've done in similar situations, and that is getting the executive committee and doing an investigation either through an independent third party or a committee of the board, depending on what the situation exactly was, to substantiate, whatever the the accusation is, or to find otherwise, but to do an investigation is the first step that I would do.
And what if the board president tells you that Michelle did this because she had to buy some very expensive experimental drug not covered by the healthcare policy, to save her husband who's got cancer, and she says she'll pay it back?
So is that a documented benefit that the board gave to her, or is that something else? Because I think that's still a problem.
Still theft, right?
Still theft.
And what are you going to do with your 990?
You're gonna have to report it depending on the amounts, right?
Well, yeah, we've hypothesized that it's big enough to be reported on the 990. So this time next year, the world will know that your executive director improperly misappropriated, X dollars. And what are you going to say that you did? You say that you did your investigation and this is what you found. Now what? Do you excuse it? Do you get her to pay it back?
I think there may also be implications of insurance coverage, and I think you've got to be very careful that whatever you do doesn't, cause the organization to lose its ability to recoup any losses that are otherwise insured. So I think the investigation that Phil talked about has got to include some consideration of, is this an insured event? Do we need to let our insurer know as well? I think you've got to factor all of those things in. I think if you start taking steps that might be forgiving of what occurred or otherwise not being deemed to be acting diligently, you may in fact fail your insurance coverage.
Yeah, now we may not care about that if she has the capacity to repay, because we may not put a claim against the insurance company to get coverage, but it's clearly an important issue to be dealt with. Okay, so we've got the executive committee saying we want to let this go. Now what does Larry do? Who's the client here?
The organization is the client.
Right. And what do you do when a group of the committee of the organization doesn't think you should do anything and you think you should do something?
Yeah, that's when you have to go to the entire board of directors, because it sounds like the board president had sort of allowed this to go on and knew about it. So you have to get the entire board involved.
And you go to them and they say, well, we're really sympathetic. Her husband was really sick. We're not going to do anything about it. Then what does Larry do? As a board member, can you leak this to the newspaper?
I don't think you can under the Florida rules.
In your capacity as a director or your capacity as a lawyer?
But in your capacity as a lawyer, I think to the extent that the lawyer is guided by the ethical legal rules, I think that the criminal element of this is a past crime, not an ongoing or future crime, as far as for embezzlement of any money. And so you could not go to the press about that. Whether or not you could go to the press with an unflattering story about a nonprofit not being willing to protect itself from employee theft, I think as a board member, that probably runs afoul of your fiduciary duty.
I think you've got a fiduciary obligation of loyalty and care, and that's to the board and the organization, not to the president or the executive director. Mm-hmm. And I think you might be able to make an argument on from the professional responsibility side that because you're talking about preventing or mitigating financial loss, particularly donor loss, right? I think that you potentially can get beyond any professional responsibility obligation to keep information confidential. I would report it to the Attorney General.
You would report to the Attorney General. Pennsylvania's Rule 1.6 is really interesting on this question, and we had this question come up a number of years ago. you can breach confidentiality to prevent a client from committing an act that is likely to result in substantial injury to the financial interest or property of another. Does that cover this case? And we can also do it, obviously, to prevent bodily injury or death. But the financial aspect, substantial injury to the financial interest or property of another. It's all past tense now, as Kathleen pointed out. It's all past tense. It's not ongoing. Do you think you have the right to go to the Attorney General at this point?
Yeah, I think that's really a tough question, and I think it models the model 1.6 same
Mhm.
issue, and I think that's ultimately the crux of the question. And I think I would still argue that that you could, and that because of the potential issues with the donors who provided those funds, again, giving the facts and circumstances, that you could argue that you can make that determination.
What did anybody else think?
I think it's a tough call, though.
We had that case in Philadelphia a number of years ago, where it was more of an ongoing circumstance, but the in-house lawyer actually went to the Attorney General. And then one of the questions was, if this is tainted information, if the in-house lawyer didn't have the right under 1.6 to disclose this, can the Attorney General use it in prosecution? And the Pennsylvania Supreme Court came down in a case named redacted versus redacted, that in fact the Attorney General could use it. But it was interesting, in that whole case, they never argued that this was permissible under 1.6, even though it could have been a continuing activity which might have been arguable under 1.6. But with past tense, you're in a little different situation. And the question is, can you disclose that? Then the question is, if you can't disclose it, or even if you can, should Larry stay around? Should Larry resign? May Larry resign? Is that the ultimate remedy for a lawyer who can't disclose but doesn't want to hang around? It's not a situation where the lawyer has been asked to participate in any criminal or fraudulent act. A lawyer hasn't been asked to sign the 990, which doesn't have this disclosure on it. But what do you do when you reach this loggerhead with this wonderful charity you just joined because you were such a good friend with the CEO? What do you do?
I think that's a hard determination for an individual to make, and I think that Larry has to decide, is his obligation to the organization best served by removing himself from it, or by staying on the board and trying to create the appropriate change within the organization. And I think as an individual, that's the first question that I would ask myself, notwithstanding my obligations as an attorney, but just as an obligation as a member of the board.
Well, might they be different?
Absolutely.
Yeah. And I think that, you're again pointing out the different hats that we wear when we serve on a board and we have any legal role at all, and they look to us for participation in that legal role. Jeff, it looks like you're coming to tell me we have run out of time. So
we have run out of time.
So
I thank everyone for their participation. Christy's going to wrap us up here with some ending announcements, but thank you to all the panelists. Thank you for all the fantastic questions. we'll be sharing some information. If you have follow-up questions, you want to reach out, please do so. But I'll turn it over to Christy.
Thank you to all the panelists and thank you for everyone for attending. I typed the CLE in the chat, but in case you didn't catch it, the Florida CLE number is 5600. Again, it's 5600, and that will get you 1 general credit and also 1 ethics credit. So that's fabulous. Thank you all for putting this together and making that happen.
Christy, if I may
Yep.
interrupt just a moment to say, use that same code to send to nonprofitissues.com and we'll get you the Pennsylvania credit.
That's right. You can email Pennsylvania credit to info@nonprofitissues.com. If you're in another state besides Florida or Pennsylvania, feel free to reach out to me. When you get the Zoom follow-up email, it'll have my email address on it. So I'm happy to help with any documentation you might need. And again, that CLE code is 5600, and you should get the email from Zoom tomorrow with the recording and the materials. So thank you all once again. I hope everyone has a wonderful weekend. Bye-bye.
Thank you all.
Thanks, guys.
Take care, everyone.
Thank you.
Thanks, everybody.